Today we are going to discuss the recent Supreme Court judgment on remission. A very important case, a very important judgment which has immense relevance as well as immense significance as far as the Indian society and democratic polity is concerned. It will take some time in order to discuss this topic, right? So, I require your patience. We will proceed systematically, one by one, step by step, right? We have also prepared a wonderful PDF for you, which covers the various aspects comprehensively. So, that material is also very much enriched. You should use it wisely for your examination. Before starting, let me tell you something about Plato. Plato, in his treatise, The Laws, claimed that the purpose of punishment is not vengeance. The purpose of punishment is not vengeance or retribution, but prevention and reformation. He added that punishment should be like a medicine, which, similar to a medicine given to a patient, the punishment is inflicted on a person to make him better. As medicine cures a person, the aim of the punishment is also to improve or better that person. Plato advances the curative theory of punishment. With these two statements. So, the punishment should be given not as vengeance, not as retribution, but the ultimate aim of punishment is to reform that person. The issue of remission should be seen in this larger philosophical context. Remission is reduction in sentence of a person. The purpose of remission is to reintegrate the person into society. When there is remission, there is reduction in sentence. It can lead to the release of that person from prison. The scope for remission or the option for remission or the presence of remission is there in all democratic societies because it is not right to keep a person in prison, without giving any scope for reform, without giving any scope for reintegration into society. Like Oscar Wilde has said, every saint has a past and every sinner has a future. The contemporary discourse on punishment is oriented towards reformation, not retribution. So if the convict can be reformed through education and various other activities, then it is in the interest of society to release that person from prison. So it is not right to keep a person in prison for his natural life. Life imprisonment is given. In general, life imprisonment means imprisonment till the natural life of that person. Simply means the person does not die, he has to remain in prison. But when this is taken, then the convict does not have any scope to be released from prison. If the convict is able to reform his approach, if the convict is able to reform psychologically while he stay in prison, if the conduct of the convict is good while he is being incarcerated in prison, then there should be scope for releasing that person by reducing his sentence in the context of remission. All mature democracies provide various constitutional and statutory rules for dealing with remission. Remission has to be seen in the larger context of clemency power. You know something about clemency power. Clemency means mercy. Mercy is shown by the state, by the people who are authorized to do that. Mercy is shown on people who are convicted of an offense. Various factors are taken into consideration before deciding on mercy. Remission is a part of the clemency power. There are various types of clemency power which you know. Pardon, commutation, respite, reprieve, remission. There are two sources of clemency power in India. One, constitutional. Article 72 and 161 of the Constitution provides the power of clemency to the President and the Governor respectively. Various sections in CRPC provides power to appropriate government for dealing with the petitions for clemency. We are dealing with the second one, statutory aspects of clemency power. We are not dealing with constitutional clemency. We are dealing with statutory clemency. You understand what is this?
An example of clemency under CRPC section it has been mentioned.
Which one?
You said about statutory source of clemency.
CRPC.
So any particular section, because I've never heard of clemency under CRPC. Article 72 and 16.
Do you think that I will not explain that? Do you think that? Do you think that if I am using the word statutory clemency, which is a new term for you, I will not be justified if I teach you superficially, which I never do. Statutory clemency means appropriate government can deal with the petitions. Appropriate government can be the state government or central government. So we are dealing with the issue of statutory clemency, whose power is with the appropriate government, which I will explain later. But now Let me give you a brief. कहाँ चला गया ये क्या हो गया? बंद कर दो इसको, वहां से बंद करो.
So this cross on top.
Virus attack. Because the topic is like this. Topic is somewhat unpalatable. Before explaining the context, before explaining various aspects of statutory clemency, let me tell you a brief background of this case, this remission. Analyzing the Supreme Court verdict on remission. This is the topic which we are going to discuss. The Supreme Court has given a verdict recently. And you are reading newspaper, you must be knowing that Supreme Court has given a verdict in the case of Bilkis Banu. Bilkis Banu 2022, Bilkis Banu versus Union of India 2022. The Supreme Court has given a verdict. I'll come to that verdict just in a bit of time. But before that, let me give you a brief background of this issue. In 2002, during the communal pogrom, communal rights in Gujarat, Bilkis Banu, along with her family members, were escaping from the riotous mob. Now I am going to read you something from the judgment of the Supreme Court itself, so that you will understand the impact and importance of this judgment. When this lady was trying to escape the murderous, riotous mob, the mob waylaid she and her family. She was 3 months pregnant. She had an infant child. The grotesque and diabolical crime in question was driven by communal hatred and resulted in 12 convicts among many. The riotous mob gang raped Bilkis Banu, gang raped her mother, killed the infant child, and as per the judgment, the petitioner's 3-year-old daughter was murdered by smashing her head on a rock. Her 2 minor brothers, 2 minor sisters, her fufa, fupi, mama, and 3 cousins were all murdered. She was pregnant at that time. Further, the petitioner's mother was gang raped and murdered. Her cousin, who had just delivered a baby, was also gang raped and murdered. 8 minors, including the petitioner's cousin, 2-day-old infant, were also murdered. This is what happened. Bilkis Banu approached, when he regained consciousness, the nearest police station. The head constable or the police officers there refused to lodge FIR. Later, because of pressure, the police registered FIR against unknown persons as accused. The local magistrate in the district accepted the closure report of the police. Closure report means accused were unknown, we cannot find who were the accused, so case is closed. Bilkis Banu approached Supreme Court. Supreme Court asked CBI to conduct re-investigation. Later, Bilkis Banu again approached Supreme Court, saying that fair trial was not possible in Gujarat. She was receiving threats and also witnesses were also being pressurized. She had to change her location and to remain under police protection. The cases were transferred from Gujarat to Maharashtra. A court in Maharashtra heard the case. 11 accused were convicted for gang rape and murder and awarded life imprisonment. The case was investigated by CBI. Some doctors and some police officers were acquitted. Lack of evidence. because when the forensic examination was conducted, I think the doctors were also complicit. And because of the complicit investigation by the police in Gujarat, police officers were also accused, but the trial court later acquitted them. But later, the higher courts convicted the police officers as well as the doctors. The 11 convicts were transferred to jails in Gujarat. They underwent nearly 14 years of imprisonment. As per one section of CRPC, which we will see later, a life convict, if he or she undergoes minimum for 14 years of imprisonment, then he or she can apply for remission. These convicts applied for remission. But the Gujarat government earlier and many other authorities, the judges and others, have provided negative opinion with respect to the remission. Simply means that the crime which they committed does not deserve any mercy. So it is not appropriate to set them free and release them in society. These convicts also approached the High Court of Gujarat. High Court of Gujarat said the appropriate government to decide your remission is Maharashtra. I will explain that, don't worry. Later, these convicts approached Supreme Court. The Supreme Court in 2022 ordered that the appropriate government to consider the remission place of these convicts is Gujarat government. And the court also said that the remission petitions of these people should be considered as per 1992 remission policy. Remission policy 1992 was the policy which was prevalent when the convicts committed that crime. For the time being, understand that 2014, the 1992 remission policy was cancelled in Gujarat. But according to Supreme Court, 1992 policy should be the governing factor while deciding remission. For the time being, understand, had the convicts remission pleas were decided as per 2014 remission policy, then they could not have got the benefits of remission, because the policy exclude those individuals who are convicted of such heinous crimes from remission. Aggrieved by the so this Supreme Court said that High Court of Government of Gujarat, you decide the remission petition within 2 months. As if the judges were very much worried about keeping such individuals, innocent people, in jails. That the Gujarat government followed some procedure. On August 15, 2022, 11 convicts were released from prison on remission. These convicts were garlanded by women and others. They were felicitated by some members of society as if they are welcoming people who have fought for the nation and who have done some good work for society. Bilkis Banu approached the Supreme Court against this remission. Along with Bilkis Banu, some conscientious people of this country, women, they also approached through PAL. They said that this remission is arbitrary. It should be quashed. One judge, a bench of the Supreme Court decided to hear this case. It is held that the government of Gujarat and the union government has tried to prolong the hearing of the case. So much so that one judge of that bench, Justice Joseph, said that, I know what you are trying to do. You are waiting for my retirement. You do not want that this bench should hear this case. Justice Joseph retired. Fortunately, the judge who replaced Justice Joseph had also had some spine left. he also upheld the oath which he took when he was sworn in as the judge of the Supreme Court. The bench led by Justice Nagaratna and Ujjal Bhuyan. Names are not important for the examination, but it is important for the period, society where we are living. The Supreme Court quashed the remission decision of the government of Gujarat. These convicts, after some days, approached Supreme Court requesting what? Requesting more time to surrender. Because the Supreme Court, when it quashed the remission order of the government of Gujarat, ordered that all the 11 convicts should surrender in the prison within 2 weeks. Couple of days before, these convicts approached the Supreme Court again, requesting more time to surrender. The Supreme Court dismissed their petition. Yesterday, 11:45 p.m., all the 11 convicts, as reported by Indian Express, surrendered in prison in Gujarat. Now, the question is, why did the Supreme Court struck down the remission orders? In order to understand this issue, it is necessary to understand some CRPC provisions. I am going to explain so-called statutory clemency for you. There are some significant provisions in CRPC which deal with various aspects of statutory clemency. Section 432 of CRPC. Section 432 of CRPC Section 432 of CRPC. Section 432 of CRPC provides for the power to suspend sentence or remit sentence. So, Section 432 CRPC provide power, remission power. Remission power to who? Remission power to appropriate government. I'll explain what is appropriate government, don't worry. Section 433 provides power for commutation to appropriate government. Section 433A provides that a person who is convicted for life imprisonment, if he or she undergoes a minimum of 14 years of imprisonment, then he can or she can apply for remission. So, 14 years. It does not say that life imprisonment is 14 years. Clear? Simply says that a person who is convicted for 14 years, or there is some other condition, don't worry. 14 years for a person who is convicted for life, if he or she undergoes imprisonment for 14 years, then he or she has the right to apply for remission. Section 434, death. When the punishment is death, both the central government and state government have concurrent power of remission, commutation, etc. 435 says consultation with central government. Section 435 mandates that there should be consultation with the central government before applying remission or commutation by the state government. In some conditions, circumstances, for example, if a case is investigated by CBI and the person is convicted and lodged in state jail, and the state government wants to apply remission or commutation, so consultation with state government is mandatory. There are a few other conditions also. So here consultation. Remember, in the context of Bilkis Banu, Case was investigated by CBI. So before remission, consultation with who? Central government was mandatory, and MHA, Ministry of Home Affairs, approved the remission orders of the Gujarat government. Now, remission power to appropriate government. The entire issue boils down to the definition of appropriate government. Appropriate government means what? It can be central government or state government. If the person is convicted against a law whose execution is with union government, then appropriate government will be union government. If a person is convicted for an offence which is under state law and which is implemented by state legislature, then appropriate government is state government. Just understand this, appropriate government can be state government or central government depending upon jurisdiction or competency. Section 432, clause 7, clause B. This is an important section, just remember 432. 432 also say that appropriate government, state government will be appropriate government where state government will be appropriate government. Which state government? The state in which the person is convicted and sentenced. That state government will be appropriate government. In Bilkis Banu case, these individuals were convicted and sentenced in Maharashtra. So ideally, Maharashtra government should have given, or the convict should have approached Maharashtra government, not the Gujarat government. So 432(7) clause B or section 432 says appropriate government when conviction and sentence is done, then that state is the appropriate government. This is the issue. The Supreme Court said, as per section 432, the appropriate government is state of Maharashtra, not state of Gujarat. Because of that reason, Supreme Court struck down the remission order given by Gujarat High Court. Gujarat government. This section says you can exercise power of remission, but remission is statutory, which means as per statute, laws. And this remission power is exercised by appropriate government, not governor or president. Government. Federal government or state government. Federal government is only one, no problem. Which state government? That state government where the person is convicted and sentenced. That is the appropriate state government which will decide the issue of remission. In Bilkis Banu case, the convicts were granted remission by Gujarat government, not Maharashtra government. So, the Gujarat government usurped, infringed, encroached upon the power of state of Maharashtra. Are you understanding what I am trying to say? But problem is not this. But the problem is, remember, it is a two-judge bench of the Supreme Court which asked the Gujarat government to decide the remission petition. This Supreme Court bench is also two-judge. That is also two-judge. So, according to the doctrine of precedence, a coordinate bench cannot overrule another decision of another coordinate bench. Two-judge bench, if you want to overrule it, then it should be at least three-judge bench. Now, if it is two-judge, the other is two-judge. The Gujarat government decided the remission petition because of the Supreme Court bench, two-judge, directed the government of Gujarat. Now, can this two-judge bench overrule the decision of another two judge bench. The Supreme Court said the decision of the earlier bench was per incuriam. What is that? Supreme Court said the judgment of the earlier bench. Which earlier bench? The bench which asked the Gujarat government to decide the remission. It said it is per incuriam. Means bad in law. Means bad in law. A decision rendered without having knowledge of law. A decision made out of ignorance. A decision which is per incuriam is not binding. A decision which is per incuriam is not binding. The decision of the earlier bench was per incuriam, bad in law. So, if a decision is bad in law, it is not binding on us. Now, why it is per incuriam? Because in Sriharan case, Sriharan 2016. In this case, the Supreme Court has categorically said, a 5-judge bench of the Supreme Court categorically said that the appropriate government is the government where the person is convicted and sentenced. So, the earlier 2-judge bench did not follow the binding precedents of Sriharan. Hence, the judgment of the 2-judge bench is not binding on this coordinate bench. Not only that, the Supreme Court said the petitioners, the convicts, played fraud on the court. They managed to get favorable orders from the court by suppressing material facts. They misrepresented facts. They did not come with clean hands in front of the court. What facts they misrepresented? They did not say to the court that they have applied for remission with Maharashtra government. They did not say that Gujarat High Court has refused our petition and Gujarat High Court has said that Maharashtra government is the appropriate government. So the order which that 2-judge bench rendered was obtained through fraud. Fraud and justice do not dwell together. All acts of justice avoid fraud. Because this 2-judge bench is obtained through fraud, manipulation and misrepresentation of fact, and also this 2-judge bench did not follow binding precedent in Sriharan, we are not bound by the 2-judge bench judgment. Are you able to understand what I am trying to say? Remember one thing, the crucial question they did not look into, which means whether those individuals who are convicted for such heinous crime, some call it crime against humanity, do they deserve leniency? Do they deserve clemency, remission? That question they did not address. But it's a vital question to discuss, which this judgment did not address, but this judgment has given some guidelines on how the remission should be exercised, the power of remission, how the power of remission should be exercised by the government per se. If you read those guidelines, I'll just show you that so that you'll understand. This one. Which one? Yes, this you see. The Supreme Court guideline for the remission in Bilkis Banu case. The judgment has summarized the various guidelines orders of Supreme Court with respect to remission in one place. if you read them, apart from the appropriation, you see, apart from the appropriate government, etc., there are some points here which shall I show you. Refund must have bearing policy. This one. In one case, Lakshman Naskar, whether the offence is an individual act of crime without affecting society at large. Which means if you are deciding an issue of remission, then the appropriate government should consider all these facts. Individual act of crime or affecting society at large. Whether any chance of future recurrence, etc., etc. So the remission policy of the appropriate government should be based upon these guidelines and considerations. Now, I'll explain that later, don't worry. This Lakshman Naskar versus State of West Bengal. In this, the Supreme Court has laid down some guidelines. So what I am trying to say is this. Fundamentally, the Supreme Court struck down the remission orders of these 11 convicts, not because of the heinousness of the crimes or otherwise, but because of illegality, arbitrariness, lack of jurisdiction or jurisdictional error, or something called overfeasance, which means exercising more power, and also the fraud played by the convicts on the court. The court has asked this convict to surrender. The convict surrendered. These convicts now have the option to apply for remission under the prevalent policy of Maharashtra as it stands. So the convicts are in jail, so it's open to them to apply for the remission policy of Maharashtra, but the Maharashtra remission policy is stringent. Because these people were convicted, I think, around 2008 something, and the remission policy which was prevalent then, 2008, exclude such criminals who are convicted of such heinous crime from the purview of remission. Or let's say they have to remain in prison for a substantial amount of period of time. Not 14 years per se. But anyway, apart from this, this judgment is of immense significance. Apart from this issue of remission, it has immense significance. What is that significance? The fundamental significance is the importance of judicial review. When it is held that, or it is said that the institutions like the courts have fallen short of expectation and the trust of the public on the Supreme Court and the various high courts have been coming down, and when the judiciary has become deferred to the executive, when there are terms being used by scholars like judicial evasion, executive court, judicial deference, judicial abdication, etc., etc., this judgment of the Supreme Court opens what we call a new era. It brings a new era of judicial review, especially when the executive arbitrary approach or arbitrary decisions are being struck down. The Supreme Court said that the Gujarat state acted in tandem with the criminals. The Gujarat state was complicit with criminals. This judgment not only struck down the remission, it criticized the activities of Gujarat government. The Supreme Court said the Gujarat government acted in tandem and was in complicit with the convicts. Had the Gujarat government filed a review petition against the two-judge bench, then the two-judge bench would have come into the knowledge of the actual legal position, but they did not do it. Not only that, all the remission orders of the 11 convicts have been stereotyped and cyclostyled. Simply means copy paste. Which means you are not applying your mind on case to case basis. You cannot have an whole scale remission. There cannot be any en masse remission. Sangeet versus State of Haryana, 2013, the Supreme Court has laid down some other conditions. One condition under that Sangeet versus State of Haryana has been there cannot be any en masse remission. There should be application of mind. Remission orders should be fair and reasonable. Remission orders should be subjected to statutory rules and guidelines. Orders should be speaking orders. Remission should be considered case to case basis, individual basis, not en masse. There cannot be any whole scale remission. However, the remission orders of the 11 convicts, according to the Supreme Court, are stereotyped and cyclostyle, which means duplicate, copy paste, no application of mind. When you do not apply your mind, when your power is discretionary, it leads to abuse of discretion. No convicts have the right, remember, no convicts have the right for remission. No convicts have the right for remission. But you have the right to be considered for remission. You have the right to be considered for remission. And when you are considering for the remission, then your decision of the appropriate authority, government, should be reasonable, fair, just. The Bilkis Banu judgment is an example of the judicial review on administrative action. Judicial review on a policy decision or decision under policy. This judgment of the Supreme Court is also an important step for safeguarding, promoting rule of law. Rule of law means what? Howsoever high or low you may be, you are subject to the same set of laws. Your political persuasion, religion, caste, and other factors do not matter. In the context of remission orders, rule of law is violated because arbitrariness was writ large on the remission orders. This judgment of the Supreme Court restores the faith of people, citizens of this country, on rule of law. It enhances the trust of individuals on judiciary as the guardian of the Constitution and protector of rights of people. This judgment is also a testament. Testament of what? A testament, or this case is also a testament, I would say. A testament of the grit and courage of a lady to fight for justice for decades. This is also a testament of a case where the civil society, women's movement, remember, some of the petitioners who filed PILs under this case were members of National Federation of Indian Women, All India Democratic Association, or All India Democratic Women Association, something like that. This was not an individual Bilkis Banu case. It was about mass sexual crimes against women. It was about justice for women as a whole. It was about women fighting for justice for women. When the entire state machinery and other institutions were complicit, some women's group and Bilkis Banu and some conscientious lawyers decided to fight for justice. So it is a victory for bringing the discourse of women rights of women, rights of victims in criminal case into the discourse, public discourse. Not only that, this judgment is also significant for the purpose of Article 32. One of the contention of the convicts when the case was being heard was Bilkis Banu cannot file Article 32 petition in the Supreme Court. She should first use Article 226 petition. You can enforce your fundamental right through Article 226 or Article 32. As per the Supreme Court judgments earlier, one view is this. If you have an alternative remedy under Article 226, then you should go to the High Court rather than coming to Supreme Court. In fact, the then Chief Justice of India, S.A. Bobde, observed in the open court. He said, we are trying to discourage Article 32 petitions. Remember, Article 32 is Part 3. Article 32 is a fundamental right. Article 32 is the soul of the Constitution, without which other rights will become nullity. Supreme Court said, Bilkis Banu has a fundamental right under Article 32 to approach the highest court of this land for enforcing her fundamental right. Fundamental rights can be enforced through Article 32. Availability of an Article 226 does not mean the Supreme Court will not entertain. Justice should be speedy and accessible. That is why Article 32 is given in the Constitution. In other words, this judgment of the Supreme Court further reinforced the importance of Article 32 for protecting the fundamental rights of people. Now the question is this. What can be done to prevent the abuse of remission power by the appropriate governments? Is it possible that there should be some guidelines, there should be some other mechanisms through which the remissions or other clemency powers are not misutilized? See, there have been a number of cases by the Supreme Court. Maru Ram 1981, Kehar Singh 1989, Maru Ram 1981, Kehar Singh 1989, Sangeet 2013, Sangeet 2013, Epuru Sudhagar 2006, etc., including Bilkis Banu. You may not be able to write, you don't have to write all these things, but keep in mind. Because Bilkis Banu judgment will provide you the entire guidelines in one place, which I have just shown you. Na? So the guidelines which are given under Bilkis Banu judgment summarizes or keeps all the other guidelines given by other judgments in one place. So whatever guidelines are given under Bilkis Banu are culled out from various other judgments, including Maruram, this is Epuru Sridhar, Sankeet, and there is one more, Lakshman Naskar. Lakshman Naskar of State of West Bengal 2015, in which the Supreme Court has laid down five criteria before granting remission. Remember one thing always. Look at the question which is given to you, whether it is clemency or remission. If it is remission only, then your focus should be on remission only. This Bilkis Banu case is on remission. Use Bilkis Banu for remission. and Lakshman Naskar for remission.
Clemency.
Huh?
Lakshman Naskar for clemency and Bilkis Banu for remission.
No. See, clemency is the this macro thing. Clemency. Question on clemency power, then you should use other cases. If it is specific on remission, then use Bilkis Banu and Lakshman Naskar. Simply use this Bilkis Banu case. For clemency, in general, you can use Madhuram, you can use, right? You can use this Epuru Sridhar. We have provided that in the booklet, Epuru Sridhar. I do not think such technical question will be asked, but keep in mind, if at all they ask, you should keep this in mind, two differences. Constitutional clemency and statutory clemency. In constitutional clemency, governor and the president are there. So Madhuram case, Sriharan case, Sangeet case, Epuru Sridhar case. All these cases will help you deal with those aspects. 72 and 161. If the question is about constitutional clemency, then you cannot write this because this is statutory.
Sir, one doubt. In 72 and 161, governor or president, they are to act on the advice of the executive. CM. And here also the state government headed by CM will decide on the clemency power. So what's the difference? I mean, it remains more.
The difference is that if you see what happened in Tamil Nadu, Perarivalan case, you must have knew. The government of Tamil Nadu recommended remission for Perarivalan, right? Perarivalan, but governor did not act upon it. The way the governors are acting these days, if you give them power, then they will not listen to the advice of consular minister. It is true that governors and president act as per COM. Here, there is no need for giving any advice to the governor or president. Right? It is given to the state government and federal government. Right? Not to the governor or president. So, in appropriate cases, and here there is no pardon. In statutory clemency, there is no there is a scope for pardoning power. No pardon. The scope of this constitutional clemency is wider than this. But anyway, these are given to the state governments for purposes, because state governments should have the power of central government, because ultimately it is the executive that manages the prison and other things. So they will know. For everything you cannot burden the governor or the president. It makes a huge difference if it is governor or the state government, especially in opposition ruled states in current context. If the governors are sitting on bills, interfering in administration, acting as political spokespersons of the federal government in opposition ruled states, then whether they are given aid and advice by the COM, they do not accept it, they really don't act on it. So it is all the more important in this current context. In the question of statutory clemency, whenever statutory remission, you should use Bilkis Banu judgment. In the question of constitutional clemency, use Epuru Sridhar, Madhuram, Sriharan, Sangeet, etc. etc. Sorry, not Sangeet, this one, Kehar Singh. You can use Sangeet versus State of Haryana for statutory clemency. Use Sangeet and Bilkis Banu. Use Sangeet and Bilkis Banu for what? This one. Statutory clemency. In Sangeet versus State of Haryana, the Supreme Court has said there cannot be any suo motu remission. There cannot be any suo motu remission by the government. Which means the government cannot by itself grant remission. Somebody has to apply. convict or the convict's relative or somebody else. There should be reasons, speaking orders, cannot be arbitrary. It should be fair and just. There cannot be any whole-scale remission. The power should not be used arbitrarily. In Lakshman Naskar, the Supreme Court has laid down some guidelines for remission. That is also given in this booklet. There are 5 points. Number 1 is whether the crime is individual or social crime. So individual or social, which means the crime is convicted, the impact of the crime is individual centric or it has wider impact on society. Number 2 is recurrence of crime, which means if the person is sent on remission, will he commit crime again? Is there a chance? Recurrence. Number 3 is potentiality, whether the person still has the potential to commit crime, physical or mental. Fourth one is whether there will be something good if he is kept under prison. Whether there is public interest, whether public interest is served if the person is kept in prison. Will there be any benefit? Will there be any, will it serve any purpose by keeping the person continuously in prison? Next is socio-economic conditions of the convict's family. Under statutory clemency, union government consent is needed in it is not needed in all cases. It is needed in cases where the conviction happens in a central law or the investigation is done by a central agency. And there are some other conditions too. Not all.
So please also discuss this. Shrivan and Kerosene judgment, what were the outcomes of these two judgments?
In Sriharan case, the Supreme Court has said the appropriate government is the government where the person is convicted and sentenced. Appropriate government is appropriate government, not governor. Appropriate government means government, not governor.
So this has to be used for statutory clemency. Because here we are talking about 432.
Because Bilkis Banu judgment rose from Sriharan. That 2-judge bench did not apply the binding precedent of Sriharan. Right? Now the question is this. Is it correct to send back the convicts into prison? Do they not deserve liberty? They have been in prison for almost 14 years, more than that, some. By sending back them to prison, are we not violating their liberty? Do they not have a right to liberty under 21? The convicts requested the court that while the case was being heard, even if you quash this remission, do not send us back to prison. But the court did not accept this contention. They were sent back to prison. And yesterday they were taken into prison in Gujarat. Is it right to send them back to prison? By sending them back to prison, isn't the court curtailing their liberty? By sending back to prison, isn't the court refusing or reducing the scope for reform? Is it not the court preventing reintegration of these individuals into society? What do you think?
The larger social interest need has to be kept in mind before taking into account their liberty.
What is the largest social interest?
We do not want to set precedent where such people convicted of heinous crimes are they are let out in the.
But there should be some legal basis for that. Cannot be a philosophical approach. Even Rajiv Gandhi convicts have also been released from prison. The former Prime Minister was killed by suicide bombers. Those convicted for death later commuted and then they were released through remission. So what is heinous crime then? What is the yardstick to measure it? Let me ask you a counter question. Whether rule of law will be maintained if the convicts are not sent back to prison? If the court respected the liberty of these people and set them free or did not undo this liberty they enjoyed, what will be its impact on freedom of, on rule of law? By allowing these convicts to enjoy freedom and liberty, will it impact rule of law? Will it maintain rule of law? Will it repose the trust and faith of people on rule of law, or will it undermine rule of law? Is there a contradiction between rule of law and right to freedom and liberty? Personal liberty and rule of law, are they contradictory? Or should they be contradictory? Or in this case, the Supreme Court has upheld or given primacy to rule of law rather than liberty of these individuals. Is it a right approach? They have been in prison for 15 years almost, although they have enjoyed liberal parole and various other furloughs. Still, the government of Gujarat said that these people have had good conduct in prison, which means that they have reformed. And one BJP MLA claimed that they belong to a particular caste, so they are sanskari people and they cannot commit such heinous crimes. Is it right? The liberty of the convicts were secured under an illegal act. A liberty which is a product of manipulation and fraud cannot sustain in a country where rule of law is supreme. Rule of law, only when there is primacy of rule of law will there be liberty. You cannot enjoy your personal freedom and liberty in the absence of rule of law. The convicts obtained their liberty through fraud. The government usurped the power which was not theirs. The entire proceedings were vitiated by fraud, arbitrariness and lack of application of mind. In essence, they were against rule of law. Liberty of a person is limited by law. Article 21 says, person's liberty cannot be taken away except as per procedure according to procedure established by law. It essentially means your liberty, you have liberty within the scope of law. No liberty is absolute. No liberty cannot be absolute. A liberty which is obtained through fraud and manipulation and by playing fraud with the court cannot be sustained. If it is so, then trust and faith of people on rule of law will suffer. Hence, compassion and sympathy have no place where rule of law has to be reigned supreme. Democratic polity and governance, rule of law is the essence. and rule of law demands that such transgressions should be dealt with iron hand. For that, rule of law will reign supreme and people's perception, their trust and faith on institutions or the Supreme Court as the sentinel on the quo vive will become stronger. The remission orders of the governments are an exercise in executive power. Remember, clemency power is not judicial power. Clemency power is executive power. All exercise of executive power should be informed by the canons of constitutionalism. All the exercise of executive power should be informed by the canons of constitutionalism. The decisions of remission taken by the government of Gujarat and the attendant liberty of the convicts violate constitutionalism, because the exercise of that executive power has been unfettered. Constitutionalism abhors absolutism. Whenever there is a power which is discretionary, that power has to be used as per the checks and balances. There cannot be any discretionary power which is unfettered and unreviewable. It is the finest hour of rule of law, when law disciplines human life and when promises meet performance. Rule of law is supreme. The Supreme Court, by sending these convicts back to prison, reinforced the trust and confidence of individuals in rule of law. For the protection of rule of law, the duty of judiciary is immense, is huge significance. It has huge significance. The court has the court has upheld this function or duty under the Constitution. But having said that, do these convicts deserve remission? Not now. Let's say I'm talking about Maharashtra government. They can apply to Maharashtra government, and Maharashtra government can consider. Remember, the Supreme Court did not say that they should not be given remission. It only ruled on the point of law. Whether there should be a category of convicts whom should not be given remission very easily. If you see various statutory rules and guidelines, policies of various state government, they have more or less exclude such individuals who are convicted of such heinous crime, mass rape, mass murder and others, from the purview of remission. Even if they have to be given the benefit of remission, the extent of incarceration is more than 14 years. Some days some 20, 28, something like that. The purpose of punishment may not be to revenge, but the purpose of punishment should be to instill confidence in society. So if you see the various policies and guidelines for the state government, there is a more or less agreement that convicts of such heinous crimes generally do not deserve remission or clemency in general. Having said so, it is necessary to provide scope for reform for convicts. Whatever crimes they commit, whatever be the nature of crimes, they should be scope for remission, scope for reform. Because hardly any purpose will be served if by keeping convicts in prison. But if you see, there are countries in the world who, the punishment process is very stringent. But anyway, the point is that, okay. If we have to classify convicts based upon their heinous nature of crime, then the classification criteria should be reasonable, fair and just. It will be difficult to classify, but still, whenever remission decision is taken, it should satisfy not only the rights of the convict, but the rights and interest of the victim and society. In this issue of remission, the convicts are worried about their own rights. If you send back to prison, then my right, liberty, etc. will be violated. What about the rights of the victim? Any rational remission policy should not only be cognizant of the rights of the convicts, but also the rights of the victim, their families, and the larger impact on society. What message are we going to send? Not only that, this judgment also creates conditions for reduction in politicization of remission. Bilkis Banu judgment is a classic example of quashing the politicization of remission. When politics becomes the important aspect, consideration for remission. Not politics, but factual matrix should be the factors of consideration. So this judgment also underscores the importance of reasonable criteria, not politicization. Not only that, a victim-centric approach to justice is also underscored. Justice is important. Not only the spelling of justice, but also the content of justice is important. Justice will lose meaning if rule of law is not enforced. Justice is meaningless without the support of rule of law. Justice cannot stand and prosper without the substructure of rule of law. The Supreme Court, by quashing the remission orders, not only upheld the issue of justice, but also reinforced our faith on rule of law and constitutionalism. Before concluding our lecture, we can say that remissions can be given. Remission is not a right, but remission should not be based on political consideration or any other extraneous reasons. There should be well thought out rational policy. That is why the Bilkis Banu judgment has laid down multiple guidelines which need to be followed. One important area is the opinion of the judge who convicted those people should be taken. It's mandatory. Remember this. Here, the judge in Bombay should have been taken. So the judge or the court who convicted. It's better to use the word court because the judge might not be transferred or let's say maybe retired. Right? So the court that convicted, the presiding judge of that court, his opinion or her opinion should be taken and should be given due consideration. Mandatory to take opinion. And the opinion of the judge should be speaking order with reasons. Why I am agreeing for granting remission, why I am not agreeing. And the government which decides the remission should give adequate weightage to this opinion. It simply means if the presiding officer does not agree, then ideally the government should not follow or continue with the remission. The government can take a review or reconsideration from the judge. Because most of the other functionaries in a committee which decides remission, generally what happens is that there is a jail advisory board at the district level. jail advisory board headed by the district magistrate, which will have some representative from social workers, some MLAs, and various other, let's say a judge from the this jurisdictional court and others. So apart from the judge, all the other in general are executive people, pure executive or affiliated to them. So generally, political confederation, various other partisan confederation come into play. So it is necessary to have that independent opinion from judiciary. That is why this Bilkisona Banu judgment said that do not include the district judge in this committee. Because this is the judge from you should take an opinion. If you are there in that committee, then majority will be for remission, maybe for remission, then the opinion of the judge cannot have any weightage. The judge cannot apply his or her own mind independently. The Model Prison Act. The Government of India recently brought the Model Prison Act. Model Prison Act, yes. It has multiple provisions for reformation. So it tries to revamp the prison system. Prison should be more focusing upon education, relearning or unlearning. Simply means to psychologically modulate the convicts, so that their propensity to commit crimes are reduced or even abolished, removed. Hardly, but the reality is that Indian prisons do not provide scope for reform. Indian prisons are overcrowded. The prison management is very poor. Hardly any scope is available for unlearning, relearning, psychological reforms, etc., learning skills, etc., etc. There are some prisons in this country, fine, but in general, move little right. I need to see board. Little right, my right, this right. Fine. What I'm trying to say is that Indian prisons need restructuring. Right? For that, the prison will work as an environment for reform. But as it stands, the Indian prisons are overcrowded and hardly provide any scope for reform. So the criminal traits, mentality, they are not removed. It will be difficult to believe that 11 convicts under this prison, when they were incarcerated, would have undergone transformation. Some convicts, when they were out on, let's say, parole and others, they were accused of, let's say, committing crimes. So it means that, prison reform is required. Prison management should be improved. For that, actual reform will happen. Remission should be aligned with conduct of the convict within prison. When remission policies are designed, the interest of the victims should also be taken into account. When the government decides remission on such heinous crime, then the proper stance of the victim should also be taken. Here the government is deciding, victim has no role. A victim-centric approach to remission should also be introduced. This is necessary for allowing remission for eligible inmates and to exclude the politicization and arbitrary application of remission. It is said that Valmikis are not born every day. Valmikis are not born every day. And given the prevailing socio-political climate in India, it is highly improbable that Valmikis will be produced. This is not I am saying, it is the Supreme Court observation in Maruram. Valmiki, if you see, who was what? He had a change of mind, he became a saint. Earlier he was having something called a bad life. You know what I am trying to refer? Valmiki, you must be knowing some kind of mythology. But he reformed. Reformed. So prison, people are there for reformation. But the court says, given the prevailing socio-political climate and other factors, it is highly inconceivable to believe that Valmikis are produced. We need to change the milieu of our prison system so that Valmikis can be produced from our prison, who can be later given remission. But remission should not be politicized. Remission cannot undermine the interest of society and the victim and rule of law. You want to ask anything, you can. Akshita, we have contacted the relevant persons for your answers. She has left. So you, left. Okay, thank you so much. Read the notes. It has significant content, right? But keep this in mind. This remission, reformation, punishment, curation, curative theory, reformative theory, restorative justice, something you study in ethics, it has an implication with that too, right? Because punishment, there are multiple theories of punishment. So remission should be seen in the context of Plato, right? Reformation, not vengeance or retribution. But anyway, but the point is that the remission should follow reform. Remission should precede reform. And the reform, whether the person reformed or not, should be scientific. Should be scientific, not arbitrary. For that, multiple factors should be taken into consideration. The interest of society should be the deciding factor when considering early release of prisoners, rather than politics and short-term political gains. The Supreme Court has done great service to the nation by reminding the powers that be that rule of law is supreme. The court is there to protect the fundamental rights of people. And if you believe in the justice system, the justice system will protect you. Anyway, I just said that Akshita, your copies will be evaluated, right? I have told the relevant persons. I think you must have received something. If not, today, tomorrow, you will receive your copies. Don't worry. So keep writing the answers. Okay, then thank you so much.